In this video, we're going to be discussing highly tested MEE topics. The purpose of going over these highly tested topics is to help you have an efficient and an effective approach to the bar exam. We find that the best way to maximize your chances of success on your bar exam is to not only focus on those highly tested subjects, but also those highly tested topics within those subjects. So just as the subjects are not treated equally on the bar exam, neither are the topics within it. So to get started, let's take a look at our frequency chart. And I'm not going to go into great detail here. This is a resource for you to come back to when you're studying, but it illustrates to you how frequently the subjects on the essay portion of your bar exam are tested. So those subjects that are very frequently tested are those like agency and partnership, corporations and LLCs, civil procedure, constitutional law, contracts, evidence, real property, and secured transactions. Now, that's not to say that the other subjects aren't tested. Of course they are, and this frequency chart illustrates that. And you should never ignore any subject or topic while preparing for the bar. But instead, to have that efficient and effective approach, you should first focus on those highly tested subjects, as well as those highly tested topics within each subject. So that brings me to my next point. Let's talk about some highly tested topics within each of our testable subjects. I'm not going to be reading this document to you. Instead, I want you to follow along with me and take any notes that you find helpful. And more importantly, I want you to come back to this document and treat it as a resource as you're preparing for the bar exam. This way you can make sure that you're covering those highly tested topics as you're cycling through your subjects in preparation for the bar. So again, I'm not going to read this to you, so follow along with me and take any notes that you find helpful. So the first subject that we come to is civil procedure. And historically, civil procedure is the most highly tested subject on the MEE. However, now, as of 2015, civil procedure is also tested on the MBE portion of your bar exam. Prior to 2015, it was not. So we think there may be a trend in testing civil procedure a little bit less on the essay portion, given that it's also tested on the other component of your bar. But nonetheless, it doesn't change the fact that it is fair game, so you should be studying it, and it is still the most highly tested subject. Within the world of civil procedure, they really like to test a few things over and over again. And again, that's not to say that they don't test other topics. Of course they do. But while you're studying civil procedure, you definitely want to make sure you are at least covering these and taking a peek at some of these essays. So these three topics that are rather heavily tested is subject matter jurisdiction, personal jurisdiction, and transfer to a more appropriate forum. So a few things that I want to say about this. When it comes to subject matter jurisdiction, it's important to remember that subject matter jurisdiction can be considered or evaluated at any stage of the proceeding. This is true even if subject matter jurisdiction is being challenged for the very first time on appeal. The theory behind this is the court has to have power to hear the matter, and even if a court rendered judgment on something or rendered an opinion on something, if they didn't have the power to hear that case, then technically their order or judgment doesn't mean anything. So subject matter jurisdiction is very important. It is not consentable. Oftentimes when they test subject matter jurisdiction on the essay portion, they're expecting you to systematically evaluate the different categories of subject matter jurisdiction. So for instance, make sure you discuss and evaluate whether or not federal question exists and diversity jurisdiction exists before getting to supplemental jurisdiction. I always like to think of supplemental jurisdiction as like the jurisdiction of last resort. So even though they like to test it, and even though it's been the correct answer, whenever it is the correct answer, the examiners also evaluate the other categories first, which means they're giving you points for your discussion and evaluation of federal question and diversity jurisdiction, even if you simply say it doesn't exist or that it is not applicable. So even if it's clear to you that supplemental jurisdiction is the correct answer, make sure you're following the correct approach and you're evaluating the other categories as well. And when it comes comes to transfers to a more appropriate forum, the one thing that I want to say about this is remember that you are applying the correct law. Oftentimes, that's really what they're testing in these questions. They'll tell you where a lawsuit is filed and that it is being transferred. And then ultimately, the question is which law applies. So make sure as you're reviewing these areas of law, specifically transfer to a more appropriate forum, you're reviewing these rules carefully. The law here tells us that when we transfer to a more appropriate forum, the new forum is their law is going to apply to that case at hand. Turning to our next subject, which is fair game, is constitutional law. And a few things that are rather heavily tested topic-wise within constitutional law is free speech, state action, the fact that Congress has the commerce power, therefore Congress can regulate interstate commerce, and the fact that Congress cannot commandeer or force the states to enforce federal laws or implement federal programs. So a few things I want to say about this. First of all, free speech. Free speech is heavily tested. And a few times the freedom of speech has been used as a defense in the context of a trespass or criminal claim. And to give you a little tip, usually the correct answer is that it is not going to be an effective defense. I'll repeat that. So usually the First Amendment is not an effective defense to some sort of trespass or criminal claim. So make sure you familiarize yourself with free speech and the different rules that apply in different forums when the government is attempting to regulate speech in those places. The next thing I want to point out here is the fact that Congress has the commerce power. So when it comes to the Dormant Commerce Clause, we're always a little bit skeptical when states are attempting to regulate interstate commerce, since this is technically a power that belongs to the federal government. So there are different tests you should be familiar with. One of the tests applies when the law passed by the state is discriminatory. In other words, when the purpose is to favor in-state versus out-of-state. If that is the case, it's going to be unconstitutional and struck down. Now, if the law is neutral, we apply like a burden-benefit analysis. We essentially evaluate the burden that's being placed on interstate commerce and what type of benefit is being derived by the state. So here, while it is likely or possible that the law could be unconstitutional, it's a little more likely we will uphold it so long as it is neutral on its face. So the way they've tested this topic in recent administrations is they give you a law in your fact pattern. Sometimes they give you multiple portions of a law that was passed, and they ask you to evaluate the constitutionality of it. And oftentimes when this has happened, different tests apply to different portions of the law because, again, they're asking you to evaluate the different pieces of it. So being familiar with these tests is helpful. So this way you know when to apply which test. Our next subject that's rather heavily tested is contracts and sales, and the topics that are frequently tested within this subject are things like Article 2 of the Uniform Commercial Code. It's tested about half the time we see a contracts and sales question. They also like to test things like contract formation and damages. So first things first, I want to circle back to Article 2, this first bullet. It's oftentimes a good place to start in response to a contracts and sales question to evaluate whether or not the common law or Article 2 is going to apply. This is a great way to pick up a few points. It's usually not worth a ton, but it's worth something. And it's also a nice way to start your essay because it gets you writing, which is going to boost your confidence a little bit. So remember that Article 2 of the Uniform Commercial Code is going to apply to a transaction in goods. A transaction simply means sales, and goods means something that is movable at the time of contracting. When it comes to contract formation, which we know, of course, is a topic they like to test, please remember they're not going to just test these basic elements. They're not just going to be asking if there's an offer or acceptance and consideration, kind of generally speaking. What they're usually testing is some of the nuances of these contract formation requirements. So for instance, in recent administrations, they've tested whether or not an offer existed and if it had been or had expired prior to acceptance. And they've also tested whether or not an offer had to be held open and could be revoked. So again, understanding these nuances of these more general pieces of law is necessary to do well on these contract formation questions. Additionally, when it comes to damages and calculations, sometimes damage calculations is just like a sub question or one of the multiple questions asked in a contracts and sales question. Other times it's the whole question, and they want you to basically break down and discuss the different parts of the damage calculation and to discuss if they're present and why. So you want to make sure you feel comfortable with damages and that this is not a portion of your outline or study that you're just skipping over and kind of hoping for the best. I know a lot of people do that for the MBE portion, but you don't want to do that on the essay portion in light of how they've tested this sometimes in the past. Now, turning to our next MBE subject that's fair game on the MBE is criminal law and criminal procedure. So back at the top of this handout where we covered our frequency chart, we actually separated criminal law and criminal procedure for you so that you could actually see how many times they were specifically tested rather than clumping them together. And what I can tell you though, is that criminal law and criminal procedure are the least highly tested subjects. They're kind of on our lowest tier of the frequently tested subjects. But that doesn't mean you want to ignore this. The most highly tested topics within criminal law and criminal procedure are things like homicide, the Fourth Amendment, and confessions, and the Fifth Amendment. So first things first, I want to talk about homicide. Oftentimes what they are testing is the different approaches to involuntary manslaughter. And what they're expecting you to do is to break down your assessment of whether or not homicide has occurred by assessing it by virtue of the basic elements of every single crime. In other words, we always need the right actus reus, we always need the correct mens rea, we need causation, and we need concurrence. And then when it comes to that mens rea requirement, and we're talking about involuntary manslaughter, there are different approaches to what that requisite mens rea is. So for instance, in the majority of jurisdictions, it requires recklessness. In the minority of jurisdictions, it requires gross negligence. And oftentimes when they've tested this in the past, they don't tell you which jurisdiction that you're in. So they're expecting you to articulate the fact that there are different approaches and then for you to analyze whether or not the person in question would be liable for that level of homicide under the majority approach as well as under the minority approach. Now, when it comes to things like the Fourth Amendment, here, use buzzwords. In other words, you want to know, if there's a search or seizure occurring, you want to use those words. You want to use things like whether or not there's a government agent that's conducting that search or seizure. You want to know the warrant requirements as well as the exceptions to it. When it comes to confessions in the Fifth Amendment, this is a good area of law to define your terms. Oftentimes when they test the Fifth Amendment, they're testing whether or not a custodial interrogation has occurred. And it's not enough to just say custodial interrogation. You want to actually define what those terms mean. So for instance, tell the graders that a person is in custody when a reasonable person would not feel free to leave. It's not necessarily just about being in handcuffs, for instance. In interrogation, define this term for the graders. It's when the police officers or government agent are asking questions or its functional equivalent. Turning to our next subject of evidence, the highly tested topics within evidence are things like hearsay, impeachment, and character evidence. And actually, in recent administrations, they've crossed over evidence with criminal procedure. So it's not uncommon to see some sort of Fifth Amendment issue being tested with hearsay. So keep that in mind. When it comes to hearsay issues, a few tips for you. Having a good approach is a great way to capture as many points as possible. So when it comes to a hearsay assessment, we find the best approach to get the most amount of points is the DIA approach. This means you're defining hearsay, you're stating why it's important to determine if a statement is or isn't hearsay, and then you're analyzing any sort of applicable exclusions or exceptions. The other tip that I have for you here, and this is a mistake that I found myself making even when I was prepping for the bar, is when they give you a statement and you're assessing whether or not it's hearsay, sometimes when you find an answer, you just stop, right? Because you think you found the correct answer and you move on. Well, if you find that a statement fits within multiple hearsay exceptions, for instance, tell the grader that, because if they too determine that, they're going to give you points for making sure you've covered all of your bases. When they test impeachment, they like to test whether or not impeachment's happening correctly. So be aware of the variety of ways that someone can be impeached. They like to test the following categories, though: impeachment by prior inconsistent statements, impeachment by conviction of a crime, prior bad acts, and then reputation or opinion for untruthfulness. It's also common for them to ask a follow-up question about whether or not extrinsic evidence is admissible to help assist in this impeachment mechanism. So you also want to be familiar with that portion of the rule at a minimum for these highly tested ways to impeach someone. Remember that extrinsic evidence is outside evidence. So it's bringing something else in to help prove the point or to help further the idea of impeachment. Turning to our next subject, real property. So I know a lot of people find real property challenging. It's challenging in the way that it's tested on the MBE. I think it's just challenging all the way around. So this is a rather highly tested subject generally, and the highly tested topics within it are deeds, recording acts, and leases. So I want to briefly discuss recording acts. You want to have a good approach to assessing a recording act question. And the best approach we find is first assessing who would win the land or own the land under a common law analysis. Common law is simply first in time, first in right. And then you want to assess the outcome under the Recording Act. And the whole purpose of doing this is because the purpose behind jurisdictions adopting recording acts is to change the common law result. So you can't figure out if the Recording Act is going to apply if you don't know whether or not the Recording Act changed the common law result. This means you have to know who would win under the common law and then who would win under the Recording Act, and then compare the outcomes. And the examiners always start with that common law assessment, and they're always allocating points to that. So you want to make sure you're capturing those points. It's relatively straightforward. The assessment is usually not complicated. It's just whether or not you point it out to the graders. So you want to make sure you're picking up those kind of straightforward points. Additionally, more recently than not, they've been testing some landlord-tenant issues like different types of leases and the duties and responsibilities of both landlords and tenants. So make sure this is something that you're not skipping over in your review of real property generally. Turning to our next subject, torts. So the topics that they like to test within this subject are negligence, and negligence by far is like the most highly tested topic within torts. And occasionally they test intentional torts, and then they like to test vicarious liability. So first I want to discuss negligence briefly. So whenever you are analyzing negligence, make sure you're breaking down the elements of it. So duty, breach, remember you need both types of causation, actual causation and proximate cause, as well as harm. They like to test premises liability, so you need to be able to distinguish what is the status of the plaintiff. And if it's unclear to you how to categorize your plaintiff, and therefore if it's unclear to you what type of duty of care was owed to them, tell the graders that. So if you can categorize your plaintiff into different categories because the facts are unclear, be sure to do that and be sure to analyze those applicable duties and whether or not they were breached based upon those different categories you've put your plaintiff in. I think sometimes people think that there is one right answer and they just pick one and then analyze it and they're leaving points on the table. So again, if something is unclear to you and it's unclear about how to categorize someone, talk about those different types of categories that would be applicable and analyze each. Now, turning to vicarious liability, this is rather heavily tested. It's not uncommon for torts and agency to be tested together, which brings us to this vicarious liability point. Vicarious liability is a great way for a principal or an employer to become liable for the actions of their agent or their employee. And this is especially true if some sort of tort occurs during the course of employment. So again, make sure you are familiar with that and these basic agency principles. Something else to remember is that the principal or employer can always be liable for their own direct negligence. This is like negligence in the hiring, in the firing, or in the supervision process of their agent or employee. Turning next to the subject of agency and partnership. So I previously mentioned that it's not uncommon to see agency tested with torts and to see those subjects crossed over with one another. But it's also not uncommon to see agency and partnership tested together. And those highly tested topics here within agency and partnership is actual authority, apparent authority, and then partnership formation. So what I briefly want to discuss is you want to have really solid definitions of actual authority and apparent authority. Oftentimes these questions are seeking if you understand that partners are agents of a partnership. They're usually giving you some sort of scenario where you have people who are running a business together and then they go and do something, like they sign a contract, for instance. And ultimately the question is that partnership going to be liable for that contract that one of those partners entered into? And to get to the bottom of that, you'll want to be able to assess and discuss agency as well as things like authority being both actual and apparent authority. So be familiar with these rules and be able to have pretty precise rule statements. So the one thing I want to point out as well is you'll notice that these are often tested together. Oftentimes these answers created by the NCBE, when they write these questions, both actual and apparent authority are applicable. So if you're noticing that a lot of these green dates match up, that is why. I find oftentimes the best time to assess whether or not a partnership, for instance, will be liable for an action taken by a partner is to first start with that actual authority assessment and then work your way through apparent authority. Turning to the next subject, somewhat similar, we're talking about corporations and LLCs. So here, the highly tested topics within this subject is the duty of care or the business judgment rule. These two things go hand in hand. Lawsuits by shareholders against a corporation, and then LLC topics or information, such as formation and rights and duties. So what I want to briefly discuss here is that business judgment rule. You want to have a solid rule statement here. One of the duties, specifically a fiduciary duty, that directors and officers owe a corporation and its shareholders is the duty of care. They also owe that fiduciary duty of the duty of loyalty. However, with the duty of care comes the business judgment rule. The business judgment rule is that really helpful presumption to those directors and or officers that basically presumes that when these directors and officers are doing something, that they're doing it because they're informed and they're doing it in good faith because they believe it's in the best interest of that entity. This means that the complainer, usually a shareholder who's trying to say that the directors or the officers did something wrong, have the burden to overcome this helpful presumption. The mistake that we see a lot of people make here is that they talk about the business judgment rule when the duty of loyalty is discussed, and that is not correct. The business judgment rule only goes with the duty of care. So you want to make sure you're not mixing these things up. When it comes to these LLC formation rights and duties issues, oftentimes people ask us, how will I know the difference between a corporation's question versus an LLC question? You know, I'm nervous that I'm going to be confusing myself or I won't know which to talk about. So first things first, the quick and easy way to determine if you're dealing with a corporation's or an LLC's question is to look at that fact pattern and look at some of the terminology that's being used. If you see the word shareholder being used, you know it's a corp's question. If you see the word members being used, you know it's an LLC's question. Now, the good news is, though, you don't have to stress too much about mixing up concepts here because oftentimes many of the concepts that are applicable in a corporation's context are going to be equally as applicable to an LLC formation or context. So that's the good news. Like I said, you kind of learn one set of rules and it's applicable to both, which is really nice. Turning to our next subject, this subject, conflict of laws, is somewhat unique. The reason this subject I call it unique is because it will never be tested on its own. This is always going to be a subject that's crossed over with other subjects, and more specifically, it's usually crossed over with those subjects of family law, civil procedure, or wills, decedence estates. And I love this because it's somewhat predictable. Whenever we see conflict of laws crossed over with these subjects, they're tested in rather predictable ways. So for instance, when it comes to crossing over family law and conflicts of law, what they're usually testing is the recognition of marriage. And usually they're testing this within the context of common law marriage. They'll tell you that parties are common law married in one place, or they'll give you facts that would lead you to the assessment of common law marriage. And then ultimately the question is, are these parties married in another jurisdiction? Meaning, do these other jurisdictions have to recognize their common law marriage? And the general answer is always yes. Common law marriage, while it's not recognized in every jurisdiction anymore, the idea is once parties are validly married in one place, that marriage will be recognized in other jurisdictions, assuming it does not violate the strong public policy of those other places. And common law marriage does not. Things like polygamy, or being married to multiple people at one time, like bigamy, those types of things are found to violate public policy, but not common law marriage. When we combine conflict of laws with civil procedure, they're usually testing the Claxton Doctrine, which is that a federal court sitting in diversity jurisdiction has to apply the choice of law approach in the state in which it sits. So to put this another way, if you have a federal judge deciding a case that came before it on diversity jurisdiction in a federal court in the state of Michigan, that judge has to apply the choice of law approach that a Michigan judge would apply sitting in a Michigan court. And whenever we see conflict of laws tested with decedents' estates or wills, they're often testing which law will apply to the distribution of assets, whether it's personal property or land. So one thing to keep in mind is that when someone dies, their personal property is going to be distributed by the law of the place in which they were domiciled at the time of death. So if at the time I die, I'm domiciled in Michigan, then my personal property assets will be distributed according to Michigan law. However, your real property is going to be controlled by the law of the situs, which is wherever it is actually located. So if you have a summer home in Florida, but you live in Nebraska, when you die, your summer home and that real property will be distributed according to the laws of Florida, which is where it's located. Turning to the subject of family law, so common law marriage, as well as custody determination and alimony or spousal support, as many people learn it, are all relatively highly tested topics here within the world of family law. My recommendation for you when it comes to common law or this first highly tested topic is know these elements. The elements of common law marriage is that we need the capacity to enter into this marital relationship. The parties have to have a present agreement to be married. They have to be living together, which is cohabitation, and they have to be holding themselves out as married. So if the fact pattern tells you that the parties agreed they would get married at some point in the future, then the parties do not have a present agreement to be married, and therefore they would be missing an element of common law marriage, and they would not be validly common law married. When it comes to custody determinations, sometimes people get really caught up in what are the best interests of the child and should I have some list of factors memorized? And honestly, the short answer to this question is no. Use your facts that are presented. In most jurisdictions, there are many things that are considered to be factors in the best interest of the child analysis. And on historical questions that test this topic, they're usually not looking for you to describe or analyze a multitude of factors. They usually give you just a small number of facts that they're looking for you to assess in relation to the best interest of the child factors. So, do I think it's helpful for you to be somewhat aware of what those factors are? Of course, but I don't think you should obsess over them. Use your fact pattern to guide you here. When it comes to alimony, sometimes the question is whether or not the spousal support order can be modified. And the general answer is in yes. The moving party must show that there's been a change in circumstances that would warrant a modification. Turning to our next subject, everyone's favorite, secured transactions, or Article 9 of the Uniform Commercial Code. So the highly tested issues here are whether or not Article 9 applies, or in other words, what it applies to. They like to test the requirements of attachment, look at all those green dates, as well as perfection and priority. So again, look at all of those green dates. Many of these topics are tested together in one question. I know that not everyone loves secured transactions. I know that it can be a rather overwhelming subject to some people and it feels foreign. My general recommendation for you to master or at least get a passing score on a secured transactions question is to focus on the basics. Understand if there is a secured transaction. Understand what it takes to perfect. Understand the basic rules of priority. Because while it's true that other issues are tested within the context of secured transactions, it's also true that the vast majority of points on a secured transactions question come from these basics. So if you can discuss the basics of attachment and whether or not there's been perfection, and then a priority dispute between creditors, even if you're missing some of the other smaller questions or finite issues being tested, you're going to get the bulk of your points, which is obviously the goal, to get that passing score. So just to recap my recommendation here, if you're unfamiliar with secured transactions, if it feels foreign and challenging to you, focus on the big picture. If you can do that, I know you can navigate your way through some of these questions. Turning to the subject of trusts and future interests, some of the highly tested topics here are trust validity, the testing of charitable trusts, as well as our trustees' duties. A trustee is a fiduciary to the beneficiaries of a trust, and one of their fiduciary duties is the duty of care. So a few things that I want to discuss here is usually when they test trust validity, one thing that we find the answers often discuss as well, they'll say something like a trust of personal property is valid if there's a trustee, a beneficiary, and trust property. But they also usually sprinkle in there that there must be a present intent to create a trust. So it's helpful if you add that sentence in as well to get those points. Now, turning to that third bullet, the duty of care, prudent administration specifically. So there are different or more fiduciary duties that a trustee owes the beneficiary. Duty of care is just one. For instance, the duty of loyalty is something that's also required of your trustee. However, the duty of care is the most highly tested or more frequently tested fiduciary duties here. So I would be familiar with the Uniform Prudent Investor Act, or the UPIA, and that's because almost all states have adopted it or some version of it, and I think that's why it makes such a nice thing to test. So this requires your trustee to administer the trust like a prudent person would. This requires them to use that reasonable care, skill, and caution. This requires a duty to diversify assets. And if there's ever sort of an allegation that this duty of care has been breached, we do not look at one transaction in isolation. We're going to look at the whole portfolio to see whether or not this trustee has done his or her job. Turning to our next subject here, wills or decedent's estates. This is our last one. So some of our highly tested topics here is will validity, slayer statutes, and intestacy. So circling back up here to creation or will validity, a few things to keep in mind is that most state laws require, in order to have a valid will, that it be in writing, that it's signed by the testator, and it's witnessed by at least two people. There are different nuances about whether or not the witnesses can be interested and what happens if they are. But this is the general rule you want to be familiar with. It's also true that about half of the jurisdictions recognize what we call holographic wills, which are essentially unwitnessed wills. It requires that your testator sign it, date it, and that the material portions of this document be in the testator's own handwriting. And then finally, there's the dispensing power, which the UPC, the Uniform Probate Code, has adopted. It essentially says that even if there is a document that is purportedly a will that doesn't satisfy your will formalities, the court can still probate it if it finds by clear and convincing evidence that the testator intended that document to, in fact, be their will. So the reason I wanted to kind of walk you through these three things briefly is if you get a question that tests will validity, it might be worth it to discuss the general rule, and if the facts do not meet that general rule, to touch upon whether or not it's a holographic will, and then finally to touch upon the dispensing power if at all necessary. And then intestacy, just to touch on this briefly, this is when someone dies without a will, or if they die with a will, but it doesn't dispose of all of their assets. It's basically when the law steps up and tells us who gets what. And there are different approaches, but the one thing I want to tell you is that the MEE isn't treating this like a math problem. They're not going to give you some sort of complicated disbursement that requires you to do a math problem to get the answer right. We know that a lot of bar prep companies test it in that way or present it in that way, and that is frustrating and overwhelming to a lot of people preparing for the bar. But if you are focusing in that way, please reassess your direction, because that is not correct. You should be familiar instead with per capita each generation and the per capita with representation approach. When it comes to intestacy, that will be very helpful to you in getting to the correct answer. So that wraps up all of our highly tested topics for the MEE. Remember, the importance of going over these is so that you're studying effectively and efficiently. Don't ignore anything, but when it comes to your review of each subject, please make sure you're hitting those highly tested topics first. This way, you're maximizing your chances of success. Don't forget to come back and use this handout as a resource as you progress through your studying.